Hello everyone, and thank you for attending today's webinar, GDPR Myths and Misperceptions. And now I would like to introduce our speakers. Duncan Brown is the Associate Vice President, European Security Practice at IDC EMEA, and leads the firm's security research program in Europe. He specializes in providing strategic advice to his clients, informing and validating their corporate, product, and marketing plans. He established and leads IDC's coverage of the global impact of the GDPR, the RPEC, and NIS directive on technology companies and their customers. His analysis and opinions are widely sought by industry leaders and investors, while his comments on industry trends and developments frequently appear in the leading business and trade publications. Peter Hughes serves as the Technical Director of Skybox Security in the United Kingdom and Ireland and has more than 20 years' experience in IT and network security. During this time, he has helped a diverse range of clients across many industry sectors to design and implement a wide range of security solutions and technologies. And now, here's Duncan.
Thank you, Debbie, for the introduction, and hello, everybody. Today we're going to be talking about GDPR myths and misperceptions, sifting fact from market hype. Of course, there is a lot of nonsense being talked about GDPR, and so we thought today we would try to clear that up, or at least some of it up. I think it's worth, though, starting right back at the beginning. Why do we have GDPR? Well, you can see from the logos on this slide that all of these companies came into existence after the arrival of the current data protection law that we have in Europe. And so there's a sense, a very strong sense in Europe that the current law that we have is unfit for purpose. These companies are gathering much more personal data in different ways and for different purposes than was ever envisaged by the existing law. So there's a need to update the existing law, and GDPR is that update. It's also really important to understand the context of GDPR insofar as it is an absolute game changer to the way in which we regard and treat personal data. Why is this? Well, the main reason is that because it represents a substantial shift in business risk. So companies that think they are doing a good job of managing data today, even those companies need to reassess the way in which they regard personal data, because the shift in business risk means that the consequences for getting it wrong are severe. Let's look at some of the ways in which GDPR risk changes. So the first of those is the introduction of fines up to 4% of global revenues. These are designed to be, as the quote says, effective, proportionate, and dissuasive. In other words, they are supposed to hurt, and they're designed to change behavior of organizations to focus their minds on the correct way of processing personal data. So they are designed to have an effect and to be painful. But it's not just the fines. In fact, when you talk to board members, they are actually more worried about mandatory breach notifications. This means that if you have a leak of personal data, you have to tell the regulators. You also have to tell the data subjects, in other words, the people whose data it is that you have lost. And clearly, once that happens, the cat is out of the bag and everybody knows about it. And so board members are actually much more worried about the loss of reputation from breach notifications. But there's more. GDPR introduces the prospect of class action lawsuits. They're not actually called that, but that's essentially what they are. And so individual data subjects can take their data controllers to court for, there doesn't even need to be any material loss. It's just a consequence of not treating data in the appropriate way, and multiple data subjects can have their interests represented by a single entity, and so there is a prospect of class action lawsuits being effected through regarding GDPR non-compliance. So that's new, and that could also be a big shift in business risk. And there's one more that I would just want to highlight, which is in extreme cases, it has to be said, the regulator can actually stop you from processing personal data. What impact does this have? Well, if you have employees, you can't process information relating to them, so you can't pay them. If you have customers, most companies or organizations do, then you wouldn't be able to process anything relating to them, so orders or customer service, all that kind of stuff. So it's effectively putting you out of operation. And so there is the ultimate sanction within GDPR. And so it's the combination of these and some other sanctions, but these are the main ones, that represent this substantial increase in business risk. In other words, even if you think you're very good at personal data, then you need to reevaluate your processes. Of course, the truth is that most companies have, to greater or lesser degree, disregarded existing data protection legislation, and so GDPR introduces these sanctions primarily to shift behaviour, to encourage us to do what we probably should be doing already, but now there's a really big consequence of not doing that, and so that is what GDPR is essentially all about, and that's why we think it is a game changer. Important also to say right up front that we at IDC think that GDPR is a good thing. As I said earlier, it updates a law which is hopelessly out of date. The existing law predates Google and Facebook and all those companies that are collecting data, and of course any other company that gathers personal data has been doing so with not very much consequence in terms of gathering consent and in terms of protecting data and so on. And so the law represents, the new law represents a timely update to the existing law. There is another major benefit of GDPR in that it unifies data protection law across all 28 member states within the EU, or should that be 27 with Brexit coming? Well, actually, we'll talk about this in just a moment, but the short story is that Brexit, in terms of GDPR, is largely irrelevant, that irrespective of the UK being in the EU or not, or in fact any country being in the EU or not, you're going to have to play to the new GDPR rules if you want to trade with the EU. As I said, we'll go into that in a little bit more detail later on. But certainly this idea of extraterritoriality is an important aspect of GDPR, and it means that if you want to play in the EU, you need to play by EU rules. Let's remind us of the timeline. The law was signed into force last April. It's a common misperception that the law will be signed in next year. That's not the case. The law is actually active now, and we are in a 2-year grace period. And so the implementation of that law and its enforcement starts from May 2018, 25th of May 2018. That's the big day. But the law is actually in force effectively now, and so we're in this 2-year transition period. So anyone who thinks that there will be a grace period after May 2018, not the case, I'm afraid. We're in that grace period right now. Okay, so let's look at a number of the myths that I hear a lot in the market. So here we go. So the first myth that I hear a lot is that it's only an EU law, and so if you're outside the EU, if you're based as a company outside the EU, or you're doing business outside the EU, then it doesn't apply. Well, not entirely. So we've heard this phrase already, extraterritoriality, which basically means that the jurisdiction of the law is extended beyond the boundaries of the European Union to other countries. So let's just have a look at the geographic scope of GDPR. So the first thing it says is that basically if you're doing business with EU companies, anything that gathers or processes personal data is in. But then it gets more interesting. It says, looking at processing data from data subjects in the EU, that's the key phrase, data subjects in the EU. If you are processing any data about a data subject, and that data subject is in the EU, so not a resident, not a citizen, just a data subject, that's a person in the EU, then you are in. And so you have industries like financial services and transport, hospitality, and so on, that need to basically understand where their data subjects are in the world in order to know whether they are in the EU and therefore whether their data is in scope. And you can see several problems or challenges with just that area. So basically what companies are doing is essentially, if they think that they have a lot of data subjects that may be in the EU from time to time, then they will just process them as though they are always in the EU. In other words, they'll just assume that they are in. In fact, they'll assume that all of their customers are in. We see that a lot. So this idea that the location of the data subject is really important. And the processing of that data is, from the scope perspective, irrelevant. Now, we're just about to talk about data transfers, but it's really important to understand this distinction. So you need to know the location of the data subject, and that's the key attribute that determines the scope from a geographic and territoriality perspective. Now, there's another interesting dimension to this. Data transfers. A data transfer is when you move the data outside, the physical data outside the EU to what's called a third country. And the basic premise is that you are not allowed to do that without, first of all, understanding that you are doing that, and also understanding into which regime are you exporting the data, and what is the data protection regime in that third country. The premise being that whatever country you move data to, you should not undermine the core principles of the EU understanding of personal data. So, for example, if you export data from the EU to a third country such as the US, does the US have an adequate or an equivalent level of data protection at a country level? The answer is no. There is no federal law in the US for data protection. So what other mechanisms are available? Well, we have this thing called Privacy Shield. That's an accepted mechanism, and so if you are signed up to Privacy Shield, then that's fine. But you don't need to be. There are other mechanisms. There are model contract clauses. There are binding corporate rules. In fact, even if you have consent from all of your data subjects that you're going to do this, then that is also a legal mechanism for exporting data. So there is a myth that you're not allowed to export data from the EU. That is wrong. You are. You just need to know the mechanism under which you are doing that. And that then assures the regulators in the EU that the data is going to be protected accordingly. That brings us to the question we quite often get is about who enforces GDPR in non-EU cases. In other words, if you are, again, for example, a US-based company and you are controlling EU data, but who's going to come after me? Well, there's a couple of ways of looking at this. First of all, it is the law, and so if you are processing EU data, personal data, then you should, because it's the law, comply with the law. But other companies may be encouraged to take a different view or a risk-based view of that. So who is actually going to come after me? Well, if you process EU data, then you must have a representative which is embodied in the EU. And it's that representative that will incur the enforcement regime of the EU. So again, if you're a US-based company processing EU data, you should have a representative in the EU, in a territory of the EU, and typical a legal entity, but it doesn't need to be. It could be just a representative, an agent, for example. But it's that agent in the EU that will incur the wrath of the regulators for any non-compliance. If you are exporting data or using Privacy Shield to provide the legal mechanism for exporting data, then the FTC is the proxy enforcement agency, and that's under the terms of Privacy Shield. So it will be the FTC that come after you. And I suppose the third thing to look at is market forces. So if data subjects are convinced that you are not protecting their data in the way that it should be, they might just shift their data to another third party who can provide those assurances. And one of the aspects of GDPR is data portability, and so you'll be obliged to provide data or allow the portability of data stored with you to a third party at the behest of a data subject. One aspect that we hear a lot about is this idea of cloud as it relates to GDPR. So it's worthwhile spending just a few moments on whether we think cloud will help or hinder the GDPR position. Okay, on the side of some of the issues, first of all, data transfers, we've talked about that already. It's important to understand that if you are doing if you're using a cloud service and the data center is not in the EU, then that is a data transfer. You're exporting data outside the EU to your non-EU data center. So you just need to make sure that you have the right legal constructs in place if you're doing that, or you have an option to locate data in an EU data center, and some cloud service providers are clearly offering that already. So from a data transfer and cloud perspective, it is important to know physically where your data is, and that is a key question that many EU organizations are asking. The next aspect is that if you are storing personal data in a cloud service, then by definition you are a data processor, and the implication here is that data processors now have liability under GDPR. Under existing EU rules, it's only the data controller that has liability, the data owner. But under GDPR, that liability extends to data processors and, in fact, their sub-processors and so on. And so it's really important that cloud service providers understand their liability for data processing and have appropriate controls and mechanisms and contracts in place that reflect that. And thirdly, because of data transfers and because of the liability extension to data processors, companies are looking for much more visibility and control from their cloud service providers so that they know what data is being stored and and physically where it is, who can access that, and so on. So providing that visibility and control from cloud service providers to their customers becomes much more important. But on the positive side, I think there's a recognition now that cloud service providers, because they operate at scale, have generally better physical security in their data center than can be normally affordably achieved by most companies, frankly. And so a lot of companies are looking towards cloud service providers to avail themselves of that better physical security. And similarly, cloud service providers have the capability and competence and knowledge and skills to provide sophisticated capability like encryption and access control. Encryption is one of these things that is really difficult to manage well, and very few companies actually have the in-house skills in order to do that, so they look to their cloud service providers or third-party key management service providers to manage it for them. So again, cloud service provision can actually simplify that aspect of GDPR compliance. It's important to know that encryption is not mandated, but it's, I think, strongly encouraged by GDPR. And thirdly, there are the emergence of several codes of conduct that cloud service providers are now signing up to, and also there are a number of ISO standards, the main ones being 27017, which is to do with cloud security, 27018 looking at the treatment of personal data in the cloud. So there are good evidence points for cloud service providers to demonstrate that they're taking their obligations seriously. So the codes of conduct or the ISO standards are good points of evidence, and that's giving a lot of confidence back to the market that cloud service providers actually understand their obligations. Myth number 2, I hear this a lot. GDPR is just like Y2K. I hear this a lot. Why is it not like Y2K? Well, the thing about Y2K was it was a binary event. It was a pass or fail test. If on January the 1st you were still operational, then you had won, and if your systems failed, you had lost, and it was kind of that. But on January 2nd, you could pretty much go back to the way things were before. And so there's this sense that GDPR is a bit of a crash diet. It's a bit like Y2K. It's we just need to put a lot of effort in very quickly before May 20th. 2018, and then we're done. Well, GDPR is not like that. GDPR is not a crash diet. It's more like a change of lifestyle. You need to do much more healthy eating, and it's a continuous change in behavior. And so this idea that you can have a project for GDPR, and then on the 26th of May, it's all over. Not the case. On the 26th of May, you still need to be compliant, and on the 27th of May, and on the 28th of May as well, and so it goes on. So this idea that you need to change your behavior is so fundamental to GDPR. So it's not a big bang approach like Y2K. It's a change in lifestyle. I hear a lot about this idea that no one is going to get fined from GDPR. Well, we don't believe that. We think that the regulators have the intent to fine for non-compliance, and I think you have to try really hard to get fined 4%. But nevertheless, there is an absolute intent with the regulators to fine for non-compliance. Why? Because GDPR is all about changing your behavior. So as I said earlier in the presentation, it's about changing behavior, and fines are one of the mechanisms that reinforce that. So in my conversations with regulators, they will take a measured approach to fining, but they will use fines. They're designed to be dissuasive, and so that's the indication we have from the regulators. The flip side to that is that everybody will get fined 4%. And again, I just don't think this will happen. You have to try really, really hard to be non-compliant, if that makes sense. The regulators will have to be convinced that you have essentially been egregious in your non-compliance to get to the 4% territory. So you need to be consistently and non-compliant and a repeat offender. So there is acceptance that in the regulator community that bad stuff happens, that cyber attacks happen, and that data will be compromised. They absolutely accept that. However, they will be looking for evidence that you know what data you have, you know that what data was lost or compromised, you were able to limit that loss, you were able to detect the breach very early and mitigate the effect of that as far as possible. So we'll be looking for ways in which you have you can demonstrate that you've been in control. And if you can demonstrate those, then it's unlikely that you would be fined 4%. Of course, the flip side is also true, that if you can't do that, if you can't evidence the fact that you've been trying hard, that you are in control, that you detected the breach early, then that's going to take you up again back towards the 4%. So if you try hard to comply, you'll be fined. If you don't, then your fine will be much higher. So it's a very pragmatic approach to fining, we expect. The next myth is that GDPR is like PCI, or in fact, any other technical standard that you might be complying with. I think this is understandable. However, it misunderstands the nature of GDPR. So if you looked at the text of GDPR, you will see that it is not prescriptive in terms of the technology controls that you need to put in place. So it's not like PCI where there's a nice handy list of things that you need to do. GDPR is not like that. GDPR basically says, in terms of security, you need to have controls appropriate to the risk. That's pretty much all it says. It makes some suggestions about things that you might want to consider, but none of that is mandated. So basically what that means, it is down to you to implement whatever technical controls, security controls that you think are deemed to be necessary, appropriate to the risk of the data that you have. So there's no doubt that if you have ISO 27001, or you are PCI compliant, or you are adhering to the NIST rules, or any other control that you have, then that's good evidence that you are trying hard, and so that will be viewed in a positive way by the regulators. But they're not mandated. And so if you can convince the regulator that you have other controls in place that are appropriate to the risk, then that's fine. So you need to make those decisions about what is appropriate to understand the risk and then take the appropriate action. So we hear a lot of concern about non-compliance, and it tends to be related to a data breach. And there's this perception that, therefore, you have to be breached in order to be non-compliant. This isn't the case, or that's not the totality of the case. So, for example, in the recent WannaCry activity, the data was not breached insofar as it wasn't lost to a third party or exposed to unauthorized third parties. However, it was encrypted. Now, in the context of GDPR, a breach includes unauthorized access to or processing of personal data. In other words, you don't actually have to lose it. It just has to be an unauthorized access. And so obviously, if you are exposed to a ransomware attack and their data is encrypted, that's unauthorized and that counts. So it's important to understand that it's not just losing data that counts. But in fact, there's a whole range of other aspects about GDPR that you could be in non-compliance with and incur a fine or other sanctions, not just a data breach. So, I've clipped a piece from the Article 83, which talks about all of the sanctions that can be imposed and relates those to a whole range of articles that that would constitute a non-compliance. So, for example, just not having a record of the data processing that you're doing is an example of non-compliance, which could incur a fine. So it's not just breaches; it's a whole range of non-compliance aspects. So the chances of a non-compliance are much higher than just having a breach. The last myth I wanted to look at is this idea that we need to be afraid of GDPR. I think that there are a number of aspects to this. First, the clock is ticking. There is a very fixed deadline for GDPR, May 25th, 2018. It's less than a year away. And so there is a lot of anxiety around the deadline. A lot of organizations increasingly worried about their state of readiness now and have a degree of fear around GDPR, largely driven by the time, also driven by the business risk increases. So there is a lot to be done for sure, but I think if organizations approach it in a structured way, then that can help them. So IDC has a technology framework to help companies prioritize their approach to GDPR. Now, it's important to understand here that GDPR is much more than a security or a technology challenge. It's a business challenge for sure. However, we think at IDC it is impossible to get compliant with GDPR without the application of technology. In other words, you need technology and business process to combine. So it's important to understand what is driving what. However, technology is, we think, fundamental to GDPR compliance. So let's look at the technology framework. The first layer is information governance. This is really looking at what data do I have, where is it, who can access it, and all these fundamental questions. Things like, why do I have this data? Do I actually need the data? Can I get rid of it? How long do I need to hold on to it? So just getting a real strong handle on information governance and to be able to answer those fundamental questions, and those are required by GDPR. You have to have answers to those, and if you can't, then by definition you're immediately in non-compliance before you do anything else. And so it's really important to get a real strong handle on information governance. The second layer is then, once you've done information governance, to look specifically at particular requirements in GDPR. So things like RTBF, right to be forgotten. Actually, the correct name is the right to erasure. So that's one key aspect. How physically do you do that? How do you manage that? There's other areas around consent. Encryption, not mandated, but strongly encouraged within GDPR. So how do you do that? Data loss prevention is, again, not mandated, but it's a really good idea to know, and so you minimize the risk associated with data breaches and so on. So there's a range of technologies that you can imagine meet specific requirements within GDPR. So if they're not covered in your information governance layer, you then need to make sure that these are covered. And then thirdly, there is a reference to this idea of state-of-the-art in GDPR, where it basically looks at taking appropriate technical and organizational measures to make your business secure. And so really what you have to do is to do a complete review of your security architecture and plug any gaps that you think represent a high business risk. So things looking at, again, encryption, but things like backup and restore, availability, testing, those kind of areas fall into that review area. Now, what's important is, I think this is an order of priority, but basically you have to get through all of these, each of these three steps before May 25th, 2018. So you can't do information governance and then stop, because that won't get you to compliance. You need to go through all three layers, but this represents the order in which we suggest you go through them. I think ultimately there is a division of the market in terms of its approach to GDPR. I love this quote from a film called Equity. The trouble with privacy is that half the world is paranoid and the other half's password is password. In other words, there seems to be a division in the world between privacy and security being an important thing and something that is completely not important. And I do sense that there is this glass half empty, half full aspect to GDPR. In other words, is GDPR a good thing that we can generate opportunity from, or is it just a chore, a regulatory chore that we have to get through? Well, what's interesting is that we've done some research into this. I just wanted to share this because there is a clear separation into those areas. So we have two broad clusters of organizations, one in the top right-hand corner that are seeking GDPR as an opportunity, and those in the bottom left-hand corner that are seeing GDPR much more as a compliance obligation, but it's never going to be more than that. And what's interesting is that, so we call the top right organizations opportunists and the bottom left obstaclers. This is an interesting way of characterizing this. And what's interesting is the blue globs relate to specific sectors. So there are generalizations clearly that apply. So we know that there are banks that operate in the bottom left-hand corner, and we know that there are transport and manufacturing companies and retailers that operate in the top right-hand corner. But by and large, on the premise of averages, this is kind of how organizations split out. But you do see this separation. You do see that there are groups of organizations that generally see an opportunity for GDPR, and that could be competitive advantage, it could be operational excellence, or some other advantage. But what we find is that those organizations that see an opportunity, it tends to be self-fulfilling. In other words, if you see an opportunity, you tend to create one, and you tend to realize the opportunities. You do realize the competitive advantage or the operational excellence. And similarly, if you don't see an opportunity, if it's just a chore, then that's all it will ever be for you. So there is a choice to be made around GDPR about whether you see compliance just as a mere obligation or an opportunity. And that is a decision that needs to be taken ultimately by the board in your organizations. And so you need to make sure that you have that discussion. Is there an opportunity to be had, or is there perhaps no opportunity for us? And so we're going to focus just on being as compliant as we think we need to be. And as long as that is a business risk decision, an informed decision, then fine. So that's all I wanted to say. Thanks for your attention, and hand over now to Peter. Thank you.
Thanks, Duncan. So now we're going to look at some of the specific areas where Skybox might be able to help you meet some of the requirements of the General Data Protection Regulation. The regulation itself comprises 11 chapters and 99 articles and doesn't really make any detailed recommendations about the types of security controls that you need to put in place, but really focuses on what the outcomes of those controls need to be. But there are 6 articles in particular where having the right technology to measure and demonstrate the effectiveness of your security controls can really help. And we'll look at how Skybox can address each of these 6 articles in turn. So firstly, Article 25, Data Protection by Design and Default. So this stipulates that we need to implement the appropriate technical measures to ensure that personal data can only be accessed for the purposes of processing. And we need to be able to demonstrate that those controls are in place. So Skybox can automatically assess and demonstrate how effective those access controls are. We do this by retrieving and interpreting the configurations of your security devices and network devices, so firewalls, IPS, vulnerability scanners, routers, load balancers, and we use this information to automatically construct a model which simulates the behavior of your network. This model can display all areas of your network, both your data center environments and cloud environments as well. And on this model, we can highlight those parts of the network which contain personal data and are therefore within scope of GDPR. And we can query the network model to identify what access exists to the personal data, representing that information visually on the map, or drilling right down into the low-level detail of individual firewall rules, address translation, and routing hops that might be used to get access. As Duncan mentioned, GDPR requires ongoing compliance, so we're able to define what we call access compliance policies that perform regular automated tests to determine what access exists to the personal data that you have within your custody. So next we've got Article 30, which requires that we maintain a record of processing activities, which includes the security controls that we have in place and, by implication, the changes to those security controls. So by automatically collecting configuration information and analyzing audit logs from your security devices, Skybox is able to track and correlate any changes that are occurring and highlight potential flaws in security configurations before they're actually implemented. So we retrieve, analyze, and interpret firewall audit logs and then correlate these with firewall configurations so that we can identify when a change was made, by whom it was made, and the precise nature of that change. Then using the Skybox Change Manager module, you can assess the security impact of changes before they actually get implemented, so we can see whether they might cause compliance issues or expose vulnerabilities. So next we've got Article 32, Security of Processing. So of all the 99 articles, this is probably the most technically prescriptive of all of them. It advises that personal data should be encrypted or obfuscated in some way, that the appropriate state-of-the-art controls must be employed to ensure ongoing confidentiality, integrity, and availability of systems which are storing or processing personal data. It should be possible to restore the availability of systems containing personal data in a timely manner, and you should perform regular testing and assessment of the effectiveness of the security controls. So in addition to modeling your network topology we've already seen, Skybox can also model the endpoints that are connected to that network. So we can pull in data from other information repositories that you've probably already got, such as configuration management databases, asset management systems, vulnerability scanners, maybe data loss prevention solutions, and highlight those systems, those servers, which contain personal data or storing or processing personal data and are therefore within scope of GDPR. And we can tag those where that data might be masked or encrypted. We can correlate what vulnerabilities exist on those assets from the information that we get from vulnerability scan results, or by cross-referencing version information from a patch management database against our own vulnerability dictionary. And then we can perform analyses to highlight which systems are most at risk because they are exposed, because we've got an understanding of the network topology and the security controls, and also those which are being active, those that contain vulnerabilities that are being actively exploited in the wild. And we can automatically assess what the risks are on an ongoing basis and highlight where there is a possibility of a loss of confidentiality, integrity, or availability on those systems specifically which contain personal data and are within scope of GDPR. And where there may be a loss of availability, we can very quickly and easily query the model that represents your network to identify if that lack of availability is due to a network connectivity issue, due to a firewall or routing problem. So Articles 33 and 34 both refer to the mandatory breach notification requirements which are within GDPR. So notifying the supervisory authority within 72 hours of identifying a breach, and also potentially notifying the data subjects. So it's essential that if you have a breach, that you are able to act in a timely fashion, identify the details and the scope of that breach, and your behavior and the ability to gather data and come up with remedial solutions within that time frame will really affect the type of fine or the size of the fines that might be levied on you by the supervisory authority, and would certainly affect your perception by your customers if you're seen to be acting in a responsible and diligent manner. So here Skybox can conduct a detailed forensic analysis against the model which represents your environment and pinpoint the precise attack path that might have been used for a breach of personal data. So in this instance, we can see that an internet hacker has exploited a vulnerability that exists on a DNS server on our New York DMZ, then takes control of that server and uses an access path that exists to exploit another vulnerability that exists on an application server in London and get access to personal data, which results in a loss of confidentiality, integrity, and availability. Now, of course, you don't have to wait for a breach to occur to find out that your GDPR data is at risk. Skybox gives you the details of these potential attack paths so that you have the information to take the necessary remediation steps and hopefully preempt a breach from occurring. So finally, Article 35 stipulates that you must conduct regular data protection impact assessments to demonstrate the effectiveness of the security controls that you've got in place protecting the personal data in your custody. So we've seen that Skybox gives you the ability to perform these ongoing automated assessments of your security controls, therefore enabling continuous compliance testing. So Skybox Horizon Manager is a high-level visualization tool that enables you to see at a glance the risk status of your environment, including the specific area that contains personal data and that would be within scope of GDPR. So we highlight what we call the indicators of exposure. So for example, we can see here that in our GDPR environments, we've got a number of poorly configured firewall rules. There are some servers with exploitable vulnerabilities, others with vulnerabilities that are exposed to access or might have exploits which are active in the wild. So we can take the necessary remediation steps to mitigate against those risks. And we can see how the risk profile has been trending over the last 6 months. So that ends the presentation portion of this webinar. If you haven't started planning for GDPR already, then now is the time to act. The worst thing you can do is to do nothing. We've got an excellent white paper available on our website on preparing for GDPR that was written by the SANS Institute. And I'd like to finish by echoing Duncan's remarks that GDPR is a good thing. I'm confident that it will change organisational behaviour and improve overall information security governance, and ultimately make it harder for the bad guys to steal our personal data. So thank you for listening, and we're now going to move on to the question and answer session, so you can still submit any questions that you may have.
Thank you, Peter. And now we're going to start Q&A. So first question, what is the best advice you could give to a company who has not yet done anything towards GDPR?
Yeah, hi Debbie. So I would say I absolutely echo what Peter's just said, which is you need to start. Yes, the worst thing you can do is put your head in the sand and pretend it's not there and hope it goes away. It will not go away, and so you need to start. Peter, do you want to add something to that?
Let's move on to the next question. I don't think he does.
Okay.
Do you think the regulator will be heavy-handed from the outset? Do you think fines will be levied from day one?
All right. So two questions there. Heavy-handed, that's a bit of a loaded term, isn't it? There is absolutely the intent to use fines to change organizations' behavior. No regulator that I have spoken to wants to do that, but they are willing to use the weapons that they have been provided. So they, as I said in my presentation, my sense is that regulators are sensible about such things. But they're looking for evidence that you are trying hard, and you get credit for that. But if you cannot evidence that, if you're not trying hard enough, then they will absolutely penalise you. And whether that's heavy-handed or not is, I guess, a matter of perspective. The other aspect of the question is, will fines be levied from day one? Sort of. So investigations will absolutely be commenced from day one. However, it takes some time to complete an investigation, and so it's extremely unlikely. I can't envisage a case where this would be where this would happen, where a fine would actually be levied from day one, because there just isn't enough time to determine the circumstances of a particular non-compliance. But the activity certainly starts from day one, yes.
Great. And what are the thresholds for compliance in terms of company size or number of records processed?
Okay. Well, the short answer is there aren't any. There were in some of the early drafts of the GDPR text, but in the reconciliation of those drafts, all of these were removed. There are a couple of areas where it's probably worthwhile just being aware of. In Article 30 that Peter mentioned in his presentation, there is a get-out for organizations with less than 250 employees, so they do not have to maintain a record of processing. That's the only exception in terms of company size. That also doesn't mean that it's not good practice. Of course, it remains that. But companies under 250 employees are not obliged to comply with Article 30. The only other thing I can think of is the data protection officer role, which is mandated for organizations that are processing what they call a large scale or large volume of data records. Begs the question, what does large mean? And there is some guidance from the Article 29 Working Group, which is the European Centre of Expertise on this. But even then, it's not definitive. One of the early drafts talked about 5,000 records being large scale, but that would be one metric, but it's not actually mandated in GDPR. So my advice would be to check that out with the regulator. But again, having a data protection officer, although it might not be mandated, is always going to be good practice.
Okay. Next question. I understand the new legislation attaches specific responsibilities to controllers and processors in terms of data handling. If the processor breaches their liabilities without the knowledge of the controller, are they held solely responsible?
So, good question. So, yes, one of the key aspects of GDPR is this extension of liability from data controllers or data owners to their suppliers, so-called data processors. And so now data processors as well are on the hook. However, it is an extension of liability, not a shift, and so the controller is never off the hook. So clearly, if a processor, if I understand the question right, if a processor has breached the liabilities, in other words, outside the contract with the controller, then they will absolutely incur the wrath of the regulator and probably the controller as well. But the controller is always on the hook, and the rationale there is that the controller did not do sufficient due diligence before signing the contract and or sufficient supervision after the contract was signed to make sure that the processor was doing what they should have been doing. And so the controller is never off the hook. So it's a really important point. Controllers are on the hook, processors are on the hook, but never in their entirety.
Okay, thank you, Duncan. And next question, what if a data subject requests access to all of their data historically, for example, say for the last 10 years? Does this have to be provided, and if so, in what time frame?
Yeah, so the short answer is yes, it does. So data subject access requests are one of the more fundamental rights that are embodied in GDPR. We talked about the right to erasure, also known as the right to be forgotten. But of course, in order to be able to forget information, you've got to know that it exists. And one of the more fundamental rights is that a data subject, so a person, can call up any company and ask them what data they have on them. That's called a request for access. And you have a month to process that request and provide all the data that you have on that data subject to the data subject. And you're not allowed to charge for it either. So we think that the number of access requests is going to increase substantially after GDPR because there is no cost to the requester, and so you can essentially make multiple requests at no cost. And there's no limit in terms of the time scale for that data. So in the scenario given by the question, last 10 years or for any time frame, yes, you've got to be able to put your hands on that data within a month. So this is a really good example of where technology is, I think, essential, because to do it manually when you have any sense of scale of personal data records, that's just unachievable. And so in order to comply with subject access requests, technology, I think, is essential.
Okay, and thank you, Duncan. Here's a question for Peter. Will buying Skybox make me compliant with GDPR?
If only if it were that simple. I would advise anybody to run a mile from any technology vendor that promised that their technology would make you compliant with GDPR or any other regulation for that matter. As Duncan said, GDPR is all about improving your sort of security lifestyle. So buying Skybox and using Skybox will improve that lifestyle. It will give you much better visibility and awareness of risks in your organization than you would have had previously. But in and on its own, it won't make you compliant, but it's a good start.
All right, well, thank you, Peter. Thank you, Duncan. We have reached the end of our hour, so thank you, everyone, for joining us today, and please have a fabulous rest of your day or evening. Thank you very much.